Namaste to all. Respected Chairman of the session, Senior Advocate S. Sanal Kumar, our special invitees, Senior Advocate Ashok Mehta, former Additional Solicitor General, Government of India, Sri M. BharatheeyaAbhibhashakaParishad, former editor, The New Indian Express, respected senior advocates, and all distinguished guests, on and off behalf of the dais, dear brothers and sisters and friends. We all are here today for remembering the sacrifices made during the emergency period of Bharat and reaffirms our commitment to democracy, rule of law and human rights. This session mainly concentrating on how the judiciary and press became handicapped during the emergency period. The judiciary, which is the very spine of democracy, the protector of the people's right, when it is impartial, fearless and independent, was made as one obeying the government policies and one committed to the government. That independence of judiciary was curtailed during the emergency period. Similarly, the press, which is the fourth estate of the realm, and as impartial as that of the independent judiciary, constitution and parliament became handcuffed, terrorized to silence by attacks over the century. A few courageous voices within the press actively resisted the censorship and restriction, notably Sri Ramnath Goenka and the Indian Express. In this session, we are blessed with such special guests who suffered the bitter experiences and are also aware of the hardships of the society during that period. My duty is to welcome all to this auspicious session. Firstly, I extend a warm welcome to our chairman of the session, Senior Advocate S. Sanal Kumar, practicing in High Court of Kerala, a jurist, writer and columnist for this session. Senior Advocate Ashok Mehta, former Additional Solicitor General, Government of India and Additional Advocate General for the State of Uttar Pradesh, is today with us for a special talk on role of judiciary as parents pathway vis-a-vis the Constitution. Sir, I extend hearty welcome to you for this auspicious session. It is my pleasure to extend a warm welcome to our guest, Sri M. BharatheeyaAbhibhashakaParishad, former editor of New Indian Express and now executive editor at Chiti, to this session. Today, Sri BharatheeyaAbhibhashakaParishad will talk on the topic, role of media as a sentinel of democracy. I extend my warm welcome to Senior Advocate Shastamangalam S. Ajit Kumar, Senior Panel Counsel, High Court of Kerala. I extend warm welcome to Advocate K. S. Rajagopal, National Council Member, BharatheeyaAbhibhashakaParishad, to this session. I extend warm welcome to Advocate B. N. Rajivan, National Council Member, to this session. I extend warm welcome to Advocate K. S. Bharathan, Advocate High Court of Kerala, Senior Panel Counsel, who is here to deliver vote of thanks in this session. I extend warm welcome to all our dignitaries, guests, advocates, our senior Karyakartas and members of BharatheeyaAbhibhashakaParishad and other Parivar organizations present here, and also all the emergency persons present here. Finally, I extend hearty welcome to all in this session. Thank you.
Thank you everyone for the warm welcome. Now we have the presidential address. We invite Senior Advocate S. Sanal Kumar Sir, patron of the BharatheeyaAbhibhashakaParishad High Court Unit, for the presidential address.
Sri Ashok Mehta Senior Advocate, Sri Rajeshekara Panikar, Sri Shastamangalam Ajit Kumar Senior Advocate, Sri K.S. Rajagopal, Sri Rajivan, and Advocate K.S. and all the special dignitaries who have assembled here and also the audience before me. I have been allotted only 5 minutes for delivering this presidential address. I will find it difficult to constrain my speech within these 5 minutes, but I will try to give a terse description or an outline of the subject which we are going to deliberate upon. In fact, I am only 55 years old now. When the emergency was declared in 1935, March 25th, June 25th, I was only a child of 5 years old. I had no direct memory or heartfelt feelings about this emergency situation and the torment suffered by the people around us. I was only 5 years old. But when I grew up and when I joined for law, then I happened to chance upon what is this emergency. So when I grew older, I gathered information about emergency and the torments and the sufferings of people who suffered for protecting democracy in India. The articles relating to Article 352, Article 359, all which we studied when we were in the law colleges. That is the only understanding about me, about this emergency, as far as myself is concerned. But later on we started reading articles, literature upon this and understood what the kind of ineffable torments and tortures the people of India suffered for protecting democracy in India. We are coming directly to the issue on the point which we are going to deliberate. That's the role of judiciary vis-a-vis the constitution. That is good some importance. It assumes importance in the background of emergency and the steadfastness with which our judiciary has fought against this emergency. That is, the entire reason is to what extent the judiciary tried to redress the grievances of the people. To my mind, that comes is 3 incidents and 3 personalities which I remember fondly when I remember about the emergency period that was prevailing here for 18 months. The first one is the Indira Gandhi's election verdict rendered by Allahabad High Court. And the man behind the judge seldom remembered. He is Jagmohan Lal Singha. We people are saying about H.R. Khanna, several other judges, luminaries, Justice B.R. Krishna, all we are saying about all the judges who actually participated or were actually engaged in the process where in the judicial process when the emergency was in force. But Jagmohan Lal Singha is one person to be remembered and he stands apart for the reason that the judgment he delivered against Mrs. Gandhi, disqualifying her for 6 years and setting aside her election was a wonderful one which we have to cherish in our memory, being lawyers, being jurists, being part of this legal profession. Because Indira Gandhi's election was challenged on the ground of corrupt practices. One Ishpal Kapoor, who was a very confident public servant of Srimati Gandhi, was actually engaged in the electioneering process. That was one of the blanks upon which this election was what we satisfied. Allahabad High Court, the last English judge of the Allahabad High Court, actually had dealt with this matter. For an election matter, for a judge, it is very easy to dismiss an election matter because there are so many technicalities are there, so many technicalities in that adjudication is involved in election petition. We see the state of election petitions are dismissed individually. In all cases, invariably in all cases. But when the change of roster took place, when the matter came before Justice Jagmohan Lal Singha, he started adjudicating this matter. He did not dismiss it. He summoned Indira Gandhi. And Indira Gandhi came there And before the day Indira Gandhi came there, it is so said in the Allahabad High Court corridors that this man warned all the judges, all the advocates that please don't stand up when the Prime Minister addressed the courtroom. The Prime Minister entered the courtroom, none stood in honor of her Prime Minister. She had to sit there for, to my knowledge, from the literature I could understand that she had to sit there for 2 days for cross-examination. After that, Jagmohan Lal Singha declared that Srimati Gandhi is disqualified for 6 years for having committed corrupt practices in her elections. The matter was again taken before the Supreme Court in appeal. In appeal, the matter was dealt with by Justice V.R. Krishnaiyer. Justice Krishnaiyer granted a conditional stay in that matter. Indira Gandhi was permitted to participate in the proceedings without a voting right. That is one episode which we have to bear in mind. The judiciary's role in the emergency period is concerned. Second one, which has already been dealt with by P. Sridhar sir, he said about the ADM Jabalpur case. The ADM Jabalpur case is one that we must remember for the reason that during emergency, by a presidential order, the right of a person, right of a citizen to approach the Supreme Court or the High Court under Article 226 or 32 for enforcement of fundamental rights was suspended. When emergency is enforced, naturally Article 19 is suspended. But by a special presidential order, it can also be the other fundamental rights, including the right to approach the constitutional courts for enforcement of fundamental rights, could also be curtailed. In the ADM Jabalpur case, this was assailed, and as Sridhar Prasad said, except Justice Khanna, all other 4 judges concurred in saying that the order, presidential order suspending this enforcement of fundamental rights and certain other provisions of the MISA Act as valid and constitutional. This is the second episode, also the second incident which we have to take care of. We have to remember only and with respect how the judiciary has reacted to the undemocratic activities of the then regime in place. Then thirdly, for the Kerala people we know, because when I was growing up, I said that the village folk used to say about the case Rajan case. The Rajan, who was an engineering student in the Regional Engineering College, Calicut, was taken into custody during the emergency period, exactly on 1/3/1976. That is after 10 months of proclamation of emergency, he was taken into custody. The father, Eachana warrior, he ran from pillar to post for getting at least the whereabouts of his son. Several representations were submitted before various authorities, and the authorities did not consider this matter. On 21st of March 1977, the emergency was lifted, Indira Gandhi was defeated. During the period, that is 1 year, the father was knocking at all doors for getting the release of the son, at least for getting whereabouts of his son. After 1 year, when the emergency was lifted, that embargo of approaching the constitutional court was taken away. Thereupon the father approached the High Court of Kerala for a writ of habeas corpus. In the writ of habeas corpus, he is standing apart for the reason that in that writ of habeas corpus, which was admitted by this court, the Kerala High Court, evidence was taken, oral evidence was taken regarding the veracity of an important fact, whether Rajan was taken into custody by the police on 1/3/1976. So these are the episodes. And the judge who, that also I must remember, this is Subramanian Murthy. And one other judge, I don't remember his name. They ordered in the habeas corpus protection of Rajan. And that order came exactly within 2 weeks after the lifting of emergency. So these are the issues, or these 3 episodes and 3 individuals we must bear in mind when we are going for remembering the cruelties, the torments, tortures, and the denial of democratic rights during emergency. I congratulate and appreciate the effort taken by the BharatheeyaAbhibhashakaParishad for convening this meeting, for sharing the reminiscences on this darker days of Indian democracy. And I wish that this is not going to happen again in our democratic system. Thank you very much.
Thank you very much, sir. We are honored to have one of the most respected legal minds amidst us, Senior Advocate Ashok Mehta, sir, former Additional Solicitor General of India. I invite Shri Ashok Mehta, sir, to speak a few words.
Legends and icons on the dais, off the dais, especially Chairman Shri Sanal Kumar ji, Senior Advocate, and the real fighter, the journalist. We have seen the cartoons. They are during the emergency from Indian Express, and Indian Express is represented on our dais by Shri Rajshekhar ji. भाइयों और बहनों, काफी कुछ तो आपने कह दिया, लेकिन मेरे को एक लाइन बोलने दीजिए और उसका इम्पैक्ट फील करिए. Feel the impact what I am going to say. Every single policeman has the right to shoot and kill everyone and anyone on the road today. Nobody has the right to question. Can anyone argue it today? Can anyone ever say these words? Yes, these are the words of Nirinde as Attorney General while arguing habeas corpus. I have used these terms in the article itself. Horrible. While this case was being argued on 26th of February 1976, a police station near Calicut was attacked and razed by some males. One of the boys there was named Rajan. The police did his own work, arrested all the Rajans available. I am telling you the truth. I have been a student of the hostel. Anyone ever lived in the room of Rajan after that was arrested? Anyone named Rajan was arrested. Anyone whose roll number was of Rajan was arrested. A fact which I faced in BHU. So I can say with the specification that here too, whomsoever name was Rajan and a young boy was arrested. But Rajan was arrested on 1st of March. And while he was being arrested, Nirinde was specifically arguing the case. In November, what the Supreme Court said, specifically I am naming two judges, Justice Baig and Justice Chandru. Please open the magazine today, hand it over to you. It will be the best way. Page number 35. Chandru says, counsel after counsel expressed the fear that during the emergency, the executive may whip and strip and starve the retinue, and if this be our judgment, even shoot him down. Such misdeeds have not tarnished the record of free India, and I have a diamond bright, diamond hand hope that such things will never come to pass. It was already happening. Second, Honorable Justice Bake. Furthermore, we understand that the care and concern bestowed by the state authorities upon the welfare of the detainees, who are well housed, well fed, and well treated, is almost maternal. माँ की तरह रखते हैं पुलिस वाले. Yes, exhibition is there. That's the truth. And within 2 days after 1st of March, Rajan was dead. Home Minister was Mr. Karnakaran. Karnakaran, as Home Minister was approached, he said, I will look into it. No other word. After that, he never allowed the father of Rajan to be there. The Rajan's book is already there, I have said. And the movie on it is also there in 2014. The book was of 2004. The facts are stated there. The judgment of the Poti is there. Soon after emergency, the state, along with the affidavit of the statement of the persons who have seen the police taking away the boy, were filed. Yes, one thing more. As soon as emergency was over, Indira lost, but Congress won in Kerala. And the Home Minister Karnakaran became the Chief Minister. When the suit was filed, when the petition was filed, Karnakaran was the Chief Minister of the state. And Poti issued the habeas corpus and issued the list and asked the boy to be present in the court. Karnakaran approached the Supreme Court. Nirende has his chance to do the question. He said, I shall appear for Rajan. Because when I was making this statement, it was my mind as a counsel. But it was not from heart. And I feel sorry for the honorable judges and the bar that none protested on that day. I have no other way but to appear for Rajan. So before the Supreme Court, in Rajan case, the former Attorney General of India appeared for the victim. The Supreme Court dismissed the case, and within 1 month of the swearing in, Karnakaran has to resign. That was the effect of the judiciary. I still say, what was there during the judiciary? Okay, one by one. First I have to say, next. Emergency, 352. Now, 44th Amendment has brought armed rebellion, internal disturbance has been removed. Next. I must say, there was 3 emergencies. We only talk about 75 to 77. Why? Why not about the 1962 emergency which continued till 68? Why I say so? The Supreme Court specifically contested and contradicted the stand of the government in IC Golaknath. That was 1967 Supreme Court, specifically saying no fundamental right can ever be amended by the Supreme Parliament. That was during emergency. In 68 that was removed. Then in 71, the war. 65 war also during the emergency. Emergency continued. Only for 68 to 71, for 3 years there was no emergency, but from 71 to 77, emergency continued. I still debate and put the question, was it necessary to impose second emergency? Internal emergency. Because the right of the center were already increased, the power of the citizens were already, rights were curtailed, the power of the state were curtailed, and even a proclamation was made on 27th of June that no petition shall lie for habeas corpus. I just want, it should be remembered, till date, the central government has misused, I will say misused, not abused, but is used and misused 134 times proclamation of president's rule. The same thing for as far as the federal government is concerned, concentrating all powers in the center. Next. Next. Well, before I further say, I have only referred to Shah Commission reports. They are not one volume, 3 volumes. They state a lot about it. The next. Prashant Bhushan and Christopher Jefferson's book is of 2010. Relevant case law. I will come to the first one. Remarkable case. No match to it. First, next, and next. 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 These are the atrocities which are covered. The detentions. 34,988 MISA detention. These are covered by the Supreme Court judgment of the habeas corpus. I am making a statement in Uttar Pradesh, the DIR cases which are 75,000 in all over India, the courts were entertaining the petition, bail. It continued to be even after that because it was the bail application and not the habeas corpus. They were issuing notice and in the meantime releasing the persons. Am I right? Was it not going on here? Well, I have been told that the first president and founding president of BharatheeyaAbhibhashakaParishad, his senior was arrested because he was arguing the cases of the detainees. Well, the ex-Chief Justice, Karnataka one, he was put behind the bar. Later on, he became the judge. Ramadas. He was the Sangh Chalak, argued for L.K. Advani because L.K. Advani was at Bangalore, put behind the bar. I will rectify one thing. At that time, the decision was taken, all Kardas will go underground, all Sanchalaks will surrender themselves and be arrested for at the age of the 80 above, climbing a pole and cutting the wires. Ideal FIRs, all cases. One more thing. None named it. None shows, yes, photograph is there. घी का डब्बा दे करके नसबंदी कर दी जा रही थी. There was a sterilization of more than 1,10,000 persons. That was the real demolition. Turkman Gate, not only there, all over India. The torture, the demolition, the molestation. The cases of the molestation has not been covered in this exhibition for the simple reason that we still grace our ladies. Demolition, sterilization, detention, and abuse of authority. 40,000 persons were compulsorily retired. And as far as judges are concerned, if a judge gave released Kuldeep Nair. The judge was again made the district judge. Our founder, President, U. Lalit's father, U.R. Lalit, was additional judge. His judgeship was not extended. After emergency, he refused to be again elevated, and we are the fortunate enough to have him as our president. There are not only one. From Gujarat, one S.K. Sheikh was transferred to Hyderabad. He joined at Hyderabad, but at the same time filed a petition that my transfer is unconstitutional. Along with him, 16 judges were transferred because they were granting the relief. 13 or 14 already joined at transfer place. But the government felt that our order of transfer has been challenged, so they don't force the rest of the 3 or 4 persons. And there was a list of 38 more honorable judges of the High Court underlined on the pipeline for transfer, which never saw the light of the day. The petition was allowed, according to me. That is the first judge's petition. First judge's case. All have forget it. They start with 1982 S.P. Gupta's case. But this transfer case is the first judge's case where Supreme Court said transfers were unconstitutional. Although it was after emergency, the judgment came after emergency, and Honorable Court settled it was settled with between the Attorney General and the Council for the Justice sake that if I am being transferred back to Gujarat, I am not pressed it. The case was not dismissed only on that ground. It has given the detailed judgment. So the atrocities was not only on the public, not only on press, but that continued with the honorable judges also. And it covers in the Shah Commission report. Shah Commission report was not available during the period of 80 to 90 and 90 onwards. But now again, it is available online, and some of the politicians have published it also. So it is still available and must be gone through. But what is the impact of it? 1973, Keshwan and Bharati case. I.C. Golaknath changed into a basic structure theory. Stands overruled Golaknath. Now just remember, 6 persons on the one side, 6 persons on the second side. The 13th one, a little bit here and a little bit there. Still not specific. Go to Khanna's statement in Keshwan and Bharati. You will find it says there is no restraint on the Constitution of India for amending the Constitution for the Parliament. But something is there which cannot be amended or must be restrained. But the property right is not such a right. So it can be amended. Now, 39th Amendment is a remarkable amendment. Next. Oh, just a minute. Previous. You have seen it that the Indian Express kept its editorial blank on 28th June. That is an exhibition also. A number of newspapers showed its opposition to the emergency in this way. One more. DEM Okri obituary. His son, freedom of L.I. Barty is taken away. That was the Times of India. So in this form, these are the things which missed censorship. The Bureau of Censorship missed all these things, and even the cartoons which are shown here were there, even in June and July. Why I am again and again talking about 39th Amendment? Next. Well, I am dividing the emergency as far as constitutional dictatorship is concerned, use, misuse and abuse of the power of the Constitution is concerned, and how far the Supreme Court played its role in safeguarding it is shown by 39th Amendment. And the amendment, yes, I may show. Representation of People's Act. That was thrice amended during that period of the case, retrospectively. Next. Okay. Grounds. Please look into the 8 grounds. Ballots counted wrongly. Chemical treatment of ballot paper. Rajnaran was saying again and again chemical was used. Everyone put this impression on my name, but it vanished because it was used chemically and erased the symbol of Congress. 600 to 700 ballots were really examined and they were found to be correct. So this ground has gone previously itself. The second one, the symbol, that was the cow and bachra. Election Commission followed its own norms. So the Supreme Court and court never agreed about it that it was a religious symbol, because Election Commission is the final authority. If anything has to be raised, it has to be raised before them. After that, the kabutar and other things and animals are removed from the list of the symbols. The third one, bribery to candidate Adityanand. 50,000 rupees, 50,000 rupees as bribery. The election petition and the election petition councils not pressed it. Now the 4 things remains. Expense limit, cross. There was a judgment of the court where the High Court said election expenses by the party or any person, if it is known to the candidate, then it should be counted. In 1975, Supreme Court said so. It was during the case, pendency of the case itself. The Indira Gandhi, yes, I will use the name, retrospectively amended it. Because Rajnaran and Shanti Bhushan were feeling, now we will gain it on this ground itself. But the Bairis were challenged of the retrospective amendment. General Senate dismissed that petition that no substantive grounds are there. Then remains Yashpal Kapoor. Interesting one. Once a person resigns, it is specifically there that once it is accepted, the resignation stands from that day. The judgment was relied upon the same analogy and said on 26th, the Yashpal Kapoor's resignation was accepted, and there is an evidence on record that he was working as an agent of Indira Gandhi prior to it. So, his working as a government servant, he also acted as election agent. So, Madam's election must be set aside on that ground. This was one, on which it was set aside. Two, government servants and armed forces help was taken in preparation of the dais and security. That was also the ground on which it was allowed. Now game is over. Rule was framed prior to it. Under those rules, Indira Gandhi has lost the election. Next. What I want to say and emphasize, that has been emphasized. In August, General Sinha was handed over the case after Broom, Srivastav and our Supreme Court judge's father, Lokur, who was also the judge of the High Court. They handled this case, but it came in the hands of the General Sinha Sahib in August 1974. And in June 75, the case was over. Yes, I just add, it was only Honorable Mr. Justice J.M.L. Sinha that this case has been decided. Otherwise, it should have been lingered upon. What happened after 12th of June? Next. There are three things which happened on 12th of June. In Gujarat, there was an election after students' agitation. The Congress lost on that day. The most trusted person of Indira Gandhi died, the Kashmiri one. And General Sinha's judgment was also there. The next. General Sinha's signature are specifically there. Held void, debarred for 6 years. They are from this paragraph from the judgment. The judgment is online. I have already passed to the Rajanji. Anyone who wants, he can have the copy of it. I have only signed because General Sinha's name is there. For me, the judgment signature was more important. I just felt that it must be known to you. Next. The Krishna Island, summer vacations. For 20 days, General Sinha stayed it. Anyone who is doing the election cases knows it if they are stayed. The case was fixed on 23rd and 24th. The arguments were heard completely on 22nd and 23rd, and it was fixed for 24th. It was in CJ's court, court number 1. Summer vacations, court number 1. The CJ's court. The court granted the limited stay which it grants in all the election petitions. Nothing more, nothing less. You continue to be member without voting. Specifically, this is the gist. That stay order really disturbed her. It is not necessary that the JP and others will be the persons. Congress has an habit. If the leader goes, the next best friend becomes the leader. It is a rule. In my Uttar Pradesh, none has completed 5 years, not even Govind Ballabh Pant. For him, the time has to be counted prior to independence also. So that was also one of the major reasons. On 25th, next. That's the story. Immediately, 2 amendments. One for acceptance of the resignation. The rule became, if the acceptance order contains a date, it will be effective from the day, it will be the date of resignation. So Yashpal Kapoor's 13th of day was accepted to be the correct one. Retrospectively amended. Second, if the government acts in its own job, performs its own job, it can do it. Now all the three grounds goes retrospectively. All the three grounds goes retrospectively by amendment of the Representation of People's Act. Now we must remember, none of the government after Indira amended it. It was never rectified. These three grounds, the expenses one, the government servants one, and resignations one. These grounds still are the same as amended at that time because it benefits political parties. It gives a random expenditure and to the parties. It was never amended. Now so, these amendments have to be changed. On 16th of July, the court opened and the case was listed and it was just we will decide it. The court, the Shanti Bhushan said, one more development. Two developments. Nariman was additional Solicitor General prior to emergency. Going to be the next Solicitor General of India. He resigned. Palkiwala appeared for Indira Gandhi in this case during the vacations. Once on 25th, the emergency was put, he backed out. He said, I will not defend now. So Ashok Sen became the counsel for Indira Gandhi. Next. Yes. That's the way the constitution can be amended by the persons in power. On 11th of August, the case was fixed. On 7th, 39th Amendment, saying that no case whatsoever, no dispute of election of Indira Gandhi will be ever filed or entertained by any court. So the 71 case also goes. No adjudication. No court will look after any election case. And constitutional amendment will also not be reviewed judicially by court. So 7th of August, Lok Sabha passed. 8th of August, Rajya Sabha passed. 9th of August, 17 states ratified it. And on 10th, President assented the bill. On 11th, when Shanti Bhushan stood to argue the case, there was a new constitution within 4 days. Only to protect her, not for any other purpose. So I divide the emergency constitutional dictatorship in two parts. One as shown by 39th Amendment, and here comes the Supreme Court. In Keshwan and Bharati, 1973, there was a division of 6 and 6. Next. Now, 7th of November, Chief Justice A.N. Ray for all amendments, no basic structure. H.R. Khanna, 50-50. M.H. Beg, freedom, all amendments allowed. No restriction, no basic structure. Matthew, spelling is wrong, sorry. Matthew, specifically in favor of Indira Gandhi, that